Okay, BADM 307 students, we're going to get into some more new material. We're going to get into property law or land law. Now, once again, like with discharge of contracts, I don't have a chapter in my textbook regarding this. For discharge of contracts, I used the chapter out of Smyth-Sober-Neeson, the previous textbook, because it was good. The property law and the mortgage chapters in Smyth-Sober-Neeson are just terrible. It's written for first-year law students and way beyond what we need. So I think for this particular portion, you're just going to have to rely on my lecture guide, and if you have any questions, just email me. But that should be sufficient for our needs. All right, so interests in land is what we're first talking about. And the first thing we do is we say, okay, let's deal with what property is. Property is everything that is subject to ownership. And then title is the ownership of the thing. Now, if you have a vehicle, you have your owner's paper, okay, and that's the title that shows that you own the car. If you have land, like a house or just a vacant lot, then you will have title issued by the land title office. So that demonstrates your ownership of the property. Now we have to look at property a little bit deeper, and on slide 108, is that 6? No, 106. We break down property into two categories. The first category is real property. That is land, buildings, and things permanently affixed thereto. So if you ask for the definition, you can't say it's things permanently affixed to the land. Okay, that's incomplete. It's the land, buildings, and things permanently affixed to. So what they're talking about is, if you I can't. I was going to lift up my computer and show you the backyard. I have trees on my lot, and they are permanently affixed to the land. And you say, no, they're not. You can hack those down. Well, yeah, you can, but when you remove something, if substantial damage is done, then the law considers that it was permanently affixed thereto. So you cut down a tree, there's stump, there's slag, there's slash, there's branches and everything. Obviously, it's considered fixed to the land. In a building, a light fixture, like on the ceiling here, is considered to be not affixed to the land because I can take that fixture off. But if I decide to take out everything else in the wiring and stuff, considerable damage would be done to the roof or the ceiling, and therefore that part would be considered permanently affixed there too. Well, in actual fact, in this day and age, nothing is permanently affixed. I mean, a nuclear bomb and everything's gone. But still, the law doesn't look at that. They just look at something that is removed. Is there substantial damage to the property? Okay, so that's real property. Lands, buildings, things permanently affixed there too. Personal property, that's everything else, okay? And personal property breaks down into two categories: tangible personal property and intangible personal property. They used to be called shows in possession and shows in action. Shows in possession because if it was tangible, they thought you could possess it, and therefore that was the distinction. Shows in action means it's not something that you could actually possess, but something that you could have a cause of action to prove your ownership. The tangible personal property and intangible personal property are better descriptions because tangible personal property is things that have value for what they are, as opposed to whether you can possess it or not. Because, for example, this loonie, and for international students, our $1 coin is nicknamed a loonie because it has a loon on it, the bird, and then our $2 coins are called toonies. Okay. Anyway, this loonie I can possess. It's very solid, but What's it worth? No, it's worth $1. No, it's not actually. The coin, the material, the metal is worth maybe 1/10 of a cent. Okay. What it represents, though, is wealth, my ability to buy a donut with it. So this is no longer considered to be tangible personal property. So what we have here is tangible personal property is my cup, okay? The coffee I drink, why? Because it's valuable for what it is. The mouse that I use is tangible personal property. My computer, tangible. My desk, tangible. My, dresser, the TV. All these things are considered to be tangible personal property. Intangible are things that have value for what they represent. Well, this loonie represents the ability for me to buy a donut. Bills, I don't have a dollar bill, but I do have a 200 peso note. These are valuable for what they represent. The paper is, the value of the paper is negligible, but what it represents is your ability to buy things. What else is intangible? Well, trademarks, for example. I have here a bag from almonds roasted with sea salt. They're called Trophy, and you can see an R in a circle there, and I'm just going to get my lecture guide off there so I can make sure. See an R in a circle there? Well, that means it's a registered trademark. I can't possess it. It's not valuable for what it is. It's a little R in a circle, but it's valuable for what it represents. It represents the trademark of that particular product. It represents the goodwill, so it's valuable for what it is. That's an R in a circle generally means that it is registered. Okay, in Canada, you've already done the intellectual property chapter, and we don't have any regulations. But generally speaking, if you are dealing with a product and it's going to the States, it has to have an R in a circle. And in Canada, usually an R in a circle means it's registered. Here is another product, organic free trade coffee, and you can see right there, hopefully you can see it, I can't see where my finger is. Anyway, you can see a T and an M. TM means trademark, and that generally in Canada means it's an unregistered trademark. In the States, it would mean an unregistered trademark because the law there says you have to have an R in a circle. Other things, patents. You have a patent on an invention. There is the invention, but the patent is what's valuable because it protects your invention. That would be intangible personal property. Industrial designs, same thing. A check. Okay. A check is, it's just some paper. Okay. But what this check represents is my ability to get, and it's reversed on the screen, but $121.16. Okay. What else? Contracts. If you have a contract and that means that you're going to sell your product and get paid on 30, 60, 90-day terms, that means that contract can actually be used by you as an asset. You can take it to the bank and say, look, I'm getting money in the future. I need an advance now. Can you give me some money? And that contract will, in fact, allow you to raise capital. What else? I think that you've got, my knees, for example, okay? If I'm injured in a car accident and I wind up in a wheelchair, I'm going to get a certain amount of money based on my loss. Okay, so for me it would be substantial, but for a hockey player or a football player or a soccer player, if they lost the use of their legs, their loss would be substantially more than mine. So a personal injury claim is an intangible asset. I think that about covers it. Well, no, let's look at something different. A painting. We don't have any in our walls here, but a painting may fall into one of the two categories. For example, the Mona Lisa, which I did get to see on a trip to France, much smaller than I thought. Anyway, it's worth, I don't know, what do they say, what, $25 million or something? Obviously, it represents wealth, okay, because the value is way beyond the value of the paint and the canvas. So that would be probably an intangible piece of property. But my deceased mother-in-law used to paint, and we used to put her paintings on the wall. And those were actually not that valuable. No disrespect to her. Some of them were very good. But they were valuable for what they were. They adorned our wall. Gold is another real problem because you have a situation where you wear a gold earring or a gold necklace. It's valuable for what it is. It adorns your appearance. A gold bar, however, you don't wear that. So obviously it represents wealth, and quite often in times when the stock market is crashing and the value of land is going down, people invest in gold as a currency, okay? All right, so those are the different types of property. Now, I guess the last thing I want to mention is you hear the word chattel. And chattel is generally something like a tangible asset, okay? It's old terminology. I mean, it's still used, but we used to have what's called a chattel mortgage. So you could get a mortgage on land to raise money. You could get a mortgage on your cars or your trucks or your equipment in your business, and it was called a chattel mortgage because it was a mortgage on tangible personal property. And if you've ever been to the Caribbean, there's a thing called a chattel house. Ooh, what's that? Well, back in the days when we had slaves, I shouldn't say we, back in the days when some people had slaves, they bought and sold the slaves, okay? Slaves were called tangible property. Well, they weren't called it. They didn't refer to them as that. But if I sold a slave to another plantation, well, that slave was probably married and had children and had to live somewhere. And so the slaves would build small houses not affixed to the ground. So in the event that they got sold, they would literally pick up their house and take it with them. So they called them chattel houses. And when you go down there and you can buy a souvenir, and it's called a chattel house, and it's a little ceramic house, right? And everybody goes, ooh, isn't that sweet? Isn't that nice? And you buy it, and it's actually representing a part of our past that we probably want to forget. Sort of like the Confederate flag in the South and Confederate monuments in the States. But anyway, that's the idea behind chattels and that term chattel house. Okay, we're going to get into the next screen, and just for a second I'm going to take a break. Okay, continuing along, what you see on slide 107 is a Latin phrase. I'm not even going to try to pronounce it, and you certainly don't have to know it for examination purposes. However, what it does mean is that the owner of land shall own the earth to its center and up to the heavens. Okay, so that would mean if you could drill down to the molten core of the earth, you could heat your house, at least for a second. But you'd own the cone all the way down to the center of the earth, and you'd own the sky to up to heaven. Well, with Yuri Gagarin, the first cosmonaut to go in space, he whipped around the earth and he said, "I see no God." Everybody realized that maybe heaven was a little farther away than they thought. And I'm being facetious here. Back in the ye old days, this was the common law attitude. Okay, the courts in the 17 and early 1800s, they said you owned the surface, everything down to the core of the earth, and the airspace above. So The 108 shows, someone standing on the earth, and it shows the portion that he or she would own. The difficulty with that, of course, is that if you owned the piece of lot or land shown on slide 109, and then they repealed the law of gravity, this is what would happen. Oh, that's my attempt at humor. The point is that we were considered to own, the surface all the way down the center of the earth into the heavens. Over time, the law has refined that considerably. You now own the surface, and you used to own everything below the surface as far down as you could use it, okay? And the airspace above your property as high as you could use it. The restrictions have gotten even more crazy because you don't own the airspace above your house as high as you can use it in Richmond. Otherwise, you would be able to build skyscrapers that are 100 and 110 stories high. Obviously, you can't because of that thing called the Vancouver International Airport. In Richmond, I'm not certain of the exact height, but I think they say that you own the area above your house up to something like 500 feet. So a 747 can fly in at 501 feet. Pretty good sound effects, eh? And everything in your house is rattling and your fillings are falling out, but there's nothing you can do about it, okay? And then the BC government, the NDP government, years ago decided that anybody that owned land had to be wealthy. Okay, wow. I just found out I'm wealthy. Anyway, so they decided that the minerals and any oil and gas underneath your property should really belong to the province as a whole. Okay, so with sweeping legislation, they took away your rights to all the minerals, gas, and oil underneath your property. That means in North Vancouver, if you discovered oil under your property, the government would actually own it, and they could actually lease out your land and have an oil company come in and drill and take the oil. You would be compensated in some regard for the disruption of your property, but you would not be compensated for the oil. Not a big deal in Vancouver, okay, or around cities or anything like that. But in the interior, with leases on land, looking for minerals and natural gas, the value of that could be substantial, but it's been taken away from you. Okay, we're now going to look at how land is carved up. And it's carved up in two ways. Estates in time and interests less than estates. Estates in time are then divided into two subcategories, freehold estates and leasehold estates. Okay, freehold estates is when you owned land, and leasehold estates is when you're just renting property. Okay, now we're going to look at freehold estates, and gosh golly gee if it isn't divided into two types. Freehold estates is defined as interests in land of an indeterminate length of time, which means when I pass away, because I've been told I am going to, I'm going to fight it, but apparently I'm going to pass away, I can pass my land down to my two daughters, and they can do with it what they want, but should they still have it when they pass away, they can pass it down to their children if they have any. What this means is that the land can stay in the Holden Stringer household or ownership for all time, with one exception, and that is in a common law jurisdiction. I really don't know about civil law jurisdictions, but in a common law jurisdiction, in Canada, the Queen has the highest ownership of land, okay? Which means I own my property subject to the Queen's right to come and say, Oh, I say, I want to build a castle there. Have this land expropriated, please. Again, being a little facetious, but let's say the government, in right of the Queen, decides that they want to put a light rapid transit through my house. They expropriate my property, and I cannot say, no, do the neighbor's property, leave mine alone, because I don't have ultimate ownership of my land. Now, I have to be compensated, okay? And if there's any problem with respect to the compensation, you can start an action against the government and seek greater compensation. That's what happened out in Richmond when they were putting the light rapid transit across the Fraser River into Surrey. Sorry, not Richmond, Surrey. And Surrey, it's Surrey. Bad jokes today. Anyway, there was a corner grocery store, and the owner was being expropriated, the government offered him a certain amount of money, and he thought it was worth more than that. And so I commenced an action, and the government came back and said, okay, let's settle this, and they gave him $60,000 more than they offered originally. So if your property is ever expropriated, bottom line, talk to a lawyer. Okay, anyway, so that's freehold estates, where you have an interest in land closest to complete ownership. Then there's this thing called life estates. And best to use an example. My father and mother bought a lot and built a retirement home on Gabriel Island with a view. It was really nice. And my mother passed away before they could move there, but my father moved there, and then a number of years later he got married again, and the woman that he was married to wanted to do some renovations to the house. Like my wife always wants to do renovations to our house. Anyway, and he said, and she invested about $25,000, and that was, in 1970, 76, 78. Okay, so $25,000 is even worth more than it is now. And she extended out the dining area and put a deck on it and everything. As my father got older, I suggested to him that he should make some arrangements to compensate Sally for this, because the house was in his name, and when he passed away, under his will, he decided to leave the house to me. That's another story, and we'll get into that at the end of this chapter. But and he said, well, how best to do that? And so I suggested that as part of the estate, the house should be valued when he passed away, and that portion of the house that she had invested in, she should be, compensated for. And then I said, and when you pass away, I'm not going to come and kick her out, obviously, but you want to protect her anyway, and so you should give her a life estate, which means my father owns the property, but on title it says that when he passes away, she gets to remain in the property for a period of time called the life of the person, meaning her. So she could stay in there until she passed away, or she could stay in there until she wanted to leave, and then the life estate comes to an end. All right? Now, there's again, two types of life estates. So it seems like there's two divided into two, divided into two, divided into two. But anyway, there's two types of life estates. One with a reversionary interest and one with a remainder interest. If my father and Sally was her name, were living there, and Sally had a life estate, if she passed away and my father was still alive, then her life estate would revert to my father. Okay? So that's a reversionary interest. When a person holding a life estate passes away, the property reverts back to the fee simple holder. A remainder interest is when a person holding a life estate passes away, the remaining interest in the property goes to a specified person. So my father and Sally are living there. My father passes away. I inherit the house, but I still cannot kick Sally out, and I wouldn't have. She was an absolute lovely lady. Anyway, she gets to remain there, but when she passes away, it does not go back to my father because my father's passed away. The remainder of the interest in the property that she owns or has would come back to me. Okay? All right. As it turned out, my father got ill and went into the hospital down in Victoria. Just to complete the story, and Sally wanted to move down there to be with him, so she got an apartment down there, and that meant the house was vacant. She had given up her life estate when my father passed away. It was dealt with under the will. Okay, now we're going to look at concurrent ownerships in land. And this is an extremely important idea, not only for the exam, but for you when you're buying and selling property, either here or if you're an international student. Check out the rules in your home country. Because what it means is in British Columbia and most common law provinces, I'm pretty sure all common law provinces, and probably Quebec too, but under the civil code there, in British Columbia, when my wife and I bought our house, both of us were put on title, the last one. Okay, remember I transferred my interest to her when I was practicing law, but I'm not anymore. So when we bought the house that we're living in right now in Gibsons, we put the title into both our names as joint tenants, which means we both have concurrent ownership with the right of survival. Okay, so when my wife passes away, the house will not go into her ownership of the portion of the house will not go into her estate. What will happen is I can apply and title will be transferred from the both of us just to me. Joint tenancy, okay. The big advantage of this, and this is something that you want to get legal advice on for sure, is that our provincial government has decided that, well, they actually decided that we should have something called death tax, okay, which means you've built up all this wonderful wealth, and when you die, some of that should go to the government because the government's so important. Anyway, it's like double taxation, okay? My whole life I work, I pay taxes, I work, I pay taxes, I work, I pay taxes, I die, whatever I own, I pay tax on. But I've bought it with after-tax dollars, okay? So double taxation is an absolute no-no in the common law jurisdiction. So when they brought in this legislation, it was challenged by lawyers and accountants. And they said that's double taxation, you cannot do that. So the government, in its infinite wisdom, said, oh, okay, well, we won't then. And what they did was they said, but we have to charge a user fee. Okay, when you die, you have to apply for probate if you have a will, or you have to apply for letters of administration if you have no will. And gosh, that's a lot of work for the government to do. And so what we should do is we should charge you a probate fee, which is not a tax. It's a user fee, okay? And it's just a way to get around the fact that they're double taxing us. It's all semantics. Yeah, I'm up on my soapbox. You can tell I'm a little upset about this. And they get away with it because let's say when I pass away, my house is worth $2 million. And it goes into my estate. And it's taxed, okay? At $14 per thousand, that would be, unless I've got this wrong, $28,000 that goes to the government, or is it more? A huge whack of money goes to the government. $14 per thousand, I think that works out to $280,000. So, my kids should be really upset, but they're getting a huge amount of money from the estate. And so they don't complain about the fact that the government has taken this big whack of money. And so the government gets away with it. So it's $14 per thousand, okay? And what they do is they value everything that you own and that goes into your estate. And then they say, well, the fee, I mean, it's so much more difficult to do a $2 million estate than it is to do a $1 million estate, than it is to do a $500,000 estate, that we have to charge you so much more, okay? No, it's not. It's a way to generate income for the government so that they can pay their big bloody salaries, as far as I can tell. Anyway, the point is that you should talk to your accountant, and if you don't have one, you better get one quickly. And you should then talk to a lawyer, and you should try to structure your estate so that when you die, your estate doesn't have any money to be taxed. So when my wife passes away, the house will come to me, okay? And what I will do at this particular point in time is I'll say, okay, when I pass away, it goes into my estate, so maybe I should put my children on title with me, and we'll all own it joint tenantly. So when I die, my interest in the property gets transferred to them. And then it does not go into the estate, and it is not taxed, okay? Bank accounts, jointly owned, GICs, RIFs, everything. Designate a beneficiary, okay? And don't just say the estate of Peter Holden, because then it goes into the estate, my estate, and gets taxed. Say beneficiary, Bridget and Alexandra, okay? And then that gets transferred to them outside the estate, and you can effectively pass away and have, almost nothing. And the government at this particular point in time says an estate worth, less than $50,000, it's not worth the bother to actually apply for probate. They don't want you to, because they're only going to get a couple of bucks, and it's a lot of work for them, right? And so what they do is they say you can have an informal probate of the estate, which means you don't have to apply to the government, you don't have to pay those taxes. So, I had a friend pass away, and we were winding up the estate, and there was a car left over, and it was used, and it was worth $17,000. And I applied to transfer title of that to one of the beneficiaries outside the estate, and that was perfectly acceptable. So you can do things like that, but you have to get legal advice, because these rules are always changing. All right, so that's joint tenancy. But what happens if I buy a lot with my brother-in-law? Okay, and we're going to own this lot, and it's going to appreciate in value, and then eventually we'll either build on it and sell it, or we'll just sell the vacant property. Well, my brother-in-law does not want to pass away and have his interests come to me. Okay, he wants his interest to go to his wife, and if his wife isn't alive, he wants his interest to go to his children. So we cannot own title as joint tenants. We would own title as tenants in common, because then he passes away and his half interest of the property goes to whomever he designates as his beneficiaries, or whoever is his heirs if he doesn't have beneficiaries. Whether it's taxed or not is completely outside my control. I just own a half interest in the property, okay? Situations like this can cause problems. For example, let's say my brother-in-law needs money and he wants to sell the lot, but I don't want to sell it because it's increasing in value. And it's going to be really hard to find somebody who's going to want to buy a half interest in a lot with somebody like me that he doesn't know. But there are some ways around this depending upon whether or not I have a greater interest than my brother-in-law, or whether I can plead to the courts that this is a tremendous hardship and I need to do this. I would have to have well over 50% of the property before I can force a sale. It's under the Partition of Property Act. Okay, but there's things you can do. Anyway, there is this right of survivorship, is the right of a surviving tenant to the interest of a deceased tenant. Tenant here is not tenants as in leasing. Tenant is as in ownership of the property, because you're really just a tenant of the Queens. Severance, if we have the property as joint tenants, let's say my wife and I get into a terrible fight and we decide to have a divorce. Well, at some point, I'm going to want to change title because, I don't want my portion of the property going to my wife who I'm fighting with. But we're on title as tenants in common, so there are steps that you can take to destroy the right of survivorship at any time without the consent of the other party. Okay, there are things you can do, and again, if you wanted to do that, my advice is get the advice of a lawyer. Okay, now that brings into question condominiums or strata ownership of property. How does that work? Because right now, for example, my wife and I own a lot in a subdivision, and we own the lot, and we'll have a fee simple ownership of that. But as to the common grounds, which means the road and the subdivision and the sidewalks and the little gardens and everything, we all belong to a strata corporation for the purposes of doing that. And then, okay, how does it work? Well, let's say there's a 4-unit townhouse complex. So there's one piece of property and 4 units. You all have a common interest in the land, and you have your own interest in your unit. And if the units are attached, then they really consider it to be in the middle of the outside wall. Okay? So the outside wall is like this, and it has a pipe going up the middle, and there's a problem with the pipe. Is it the occupier of that unit that has to pay for the pipe repair, or is it the strata corporation? So you have to check into those things when you're buying condominiums. Most, if not all, provinces have enacted legislation permitting the granting of these partial interests in land. Okay, leasehold estates, an interest in but not ownership of land for a definite period of time. Now we're talking about renting property, okay? So I see a mistake on my overhead, and I'm just going to stop here for a second and repair that mistake so I remember to do it, and then I'll pick this up in a minute. All right, I'm back. After making those corrections, on slide 112, we could see that estates in time were broken down into freehold estates and leasehold estates. So then on 113 and 114, we were talking about freehold estates, and then on 114 there's a small b and it says leasehold estates, an interest in but not ownership of land for a definite period of time. That's the second type of freehold estate. So, but I'm not going to talk about that right now. I'm going to come back to that in a minute. What now I want to do is talk about things that affect your fee simple interest in property. And these are called interests less than estates, okay? And the first one is an easement. It's a right enjoyed by one landowner over the land of another and is obtained for a special purpose rather than for the general use and occupation of the land. The next one is called a right of way, where the holder may pass back and forth over the land of another to get to and from his land. And then the third is a covenant, where the owner of property wants to sell it but wants to control the use of it in some way in the future. All right, backing up, easement. My wife and I, when we were thinking about moving up to the Sunshine Coast, we're actually looking at properties everywhere, and we found this lot out in Tawasin, a nice house on this lot, and it had a swimming pool. And so we were quite interested in buying that. And we asked for a copy of the certificate of title, and on there was an easement at the back of the property. Well, at the back of the property, the pool was lovely, and it had this cement area all around it, right? And the cement went up to the back of the property, and the easement seemed to go under that cement, and it went under the pool house. And so I asked the real estate agent if what that easement was and should I be concerned about it. And she said, "Oh, no, don't worry about it. It's an easement for the sewer line for the Tawasin area, and it'll never, ever be used. It just means that the pipe runs into your property." And she was lying, okay? Because it's a verbal representation with respect to land. We'd never be able to prove that she said it if there was a problem in the future. Anyway, I began doing a little bit of investigating, and there was a huge subdivision going in, like huge, massive subdivision over here. And the sewer line ran through the back of our property. And so I went down to the city hall, and I said, the sewer line from this subdivision, where does it go? And he says, "Oh, well, it's the one that goes into the back of your property if you buy it." And I said, "Oh, is the sewer line big enough to handle that?" "Oh, no, they'll probably have to put in a bigger pipe." Which meant they'd have to rip up the cement, and probably we'd have to empty the pool, and they have an easement to do that, so we don't get to say, "Hey, you're causing us money." So all that cost would have been ours, okay? So I think you have to be really careful, because as with lawyers, as with judges, as with police, as with business owners, as with everybody else, there are honest people and then there are dishonest people. Okay, and that real estate agent was just being dishonest. As a matter of fact, there were a couple of other issues. One was it had a metal roof, and I asked about the thickness of the insulation, sound insulation between the roof and the metal over the roof. And she told me that it was really thick. I can't remember how big, right? And so there'd be lots of sound protection so the metal roof wouldn't cause a problem. At the back corner of the house, there was a piece of the metal roof missing, and you could see the foam insulation, and it was as thin as can be. And so my wife and I did the inspection ourselves. We've looked at so many houses that we can basically do a decent inspection. I went in the hallway, and my wife used a hose and did and put the water onto the roof just above the hallway, and you could hear it like nobody's business. So I called the real estate agent on it, and it was like, "Oh, really? Well, I was told it was really thick." Now, she's a professional, or supposedly she should have done the investigation herself and ensured that it was. But and then the other thing was there was an area, like there was the kitchen area, and then there was a little sort of somewhat outside area but covered where you could have breakfast and dinner if you wanted. And there was a light there, a light fixture, and I went, and it didn't go on. And she said, "Oh, it's just a burned out bulb." And so I said, "Oh, okay." So when we came back to do the inspection, I took out a bulb that I knew worked, and I put it in there, and it didn't work. Okay. Checked the circuit breaker was on. So again, there was some problem with the wiring, and it's just a burned out bulb. And then the other thing was in the master bedroom upstairs. It was wonderful. This huge master bedroom and a huge king size bed. And beside the bed there was the bedside tables, and on there was a phone. And as I was walking by, I sort of picked it up and I listened, and there was no dial tone. So I got down and I went under the bed and I pulled the cord from the phone. It wasn't plugged in. So I moved the bed. There was no place to plug it in. So anyway, needless to say, we didn't buy that house. We bought up in the Sunshine Coast, and it was the best decision we ever made. Anyway, you have to do your investigating, and you should not take at face value anything that a real estate agent says. Okay, you really have to do your own investigating, and get a lawyer, do your investigating. Okay. Anyway, that's an easement. The other landowner, the government of Tawasin, okay, the municipal government, owns lots of land, and they owned that subdivision or whatever, and they enjoyed the right over our land, not occupying it. They're not going to like sit there, but they have the right for a special reason, and that was the running the sewer line through. Okay, right away, another anecdote. I got lots of anecdotes. My brother-in-law in Ontario, common law, same as us, bought a lot on Bob's Lake. Okay, that's the name of the lake, Bob's Lake. And between the lake and the road, there was this piece of property. It was huge, and the road from the main road out here to the cottage sort of snaked through this property. And when he bought the property, he went to check to see if, in fact, there was a right-of-way allowing him to pass over this other person's property. Otherwise, he would have bought a lot on the lake and it would have had to have gone in by helicopter. Otherwise, he'd be trespassing. So there's this right-of-way. Now, the dominant tenement is the piece of land that is to benefit from the easement. So that was the lot on the lake. The servient tenement is the land between the outside road and that lot on the lake. Okay, the servient tenant is the land subject to that particular, what they call an easement, but it's actually a right-of-way. Okay, then the third category is a covenant. Often an owner wants to sell a portion of his property and control or restrict the use of the portion sold. Way back in the history of British Columbia, the owner of all the land in West Vancouver put a restrictive covenant on all the property that said the property could be sold, but not to blacks, Chinese, or Jewish people. Okay, and over time, that covenant, because it was so obnoxious and out of step with the direction of society, became ignored. You got to say ignored because it was still on the property. There was a lady that bought a piece of land in West Vancouver, and she asked the real estate agent about that covenant, and the real estate agent explained what the covenant was, but that it was inoperative and that it would not affect her. She was so upset by that restrictive covenant that she wanted to get it removed. But the only way it could be taken off is if all the owners of the property affected by the restrictive covenant agreed. And so she had her lawyer draft up the document to release the covenant, and then went around house to house and talked to all these people, and I can't remember, it was somewhere between 40 and 80 households, and everyone was so appalled at the content of this covenant that she actually got all the signatures and it was released from the land. Okay, but there are other restrictive covenants that are not quite as obnoxious. There was one situation where there was a strata corporation, and they had a restrictive covenant on the strata corporation because they wanted all the strata units colored, painted the same colors for consistency and appearance, right? And they also wanted only daffodils planted as the spring flowers. Well, everybody planted daffodils outside their units except this one house that planted tulips. And everybody else got really upset about it, and they said, like, tough, right? And so the other strata owners took this person to court and said they wanted the restrictive covenant enforced. And the funny thing, they wanted to get an injunction. And they had to get an injunction to stop her from not planting daffodils. Okay, you cannot get an injunction to make her plant daffodils. For some reason, injunctions have to be negative, and so they had to get an injunction to stop her from not planting daffodils. We lived in a 4-unit townhouse complex in North Vancouver, and we had common colors, and it was a very attractive place. And the owners of Unit D decided that they wanted to paint their front door pink. All this, anyway, enough said. Before the units got together and they said, well, okay, you want to do it, do it. And they painted it pink, and it was horrible. But it felt nice to them. Unfortunately, they sold, and the next people that came in said, why is our door pink? And they had it reverted back to the original color. So, but we had left by that time, so it didn't matter. Okay. So these are restrictive covenants, and they're called covenants running with the land. Okay, because they go from owner to owner to owner to owner. They don't change with the ownership. All right. We had interests. I'm sorry. Let's just get back to make sure I use the right terminology. Estates in time, and then we have interests less than estates. Now we're getting down to the interests less than estates. We don't have to worry about this too much because it really doesn't affect anyone in the city. But if you have property and it turns out that there is minerals or oil or natural gas below it, this is the way that the government of British Columbia can come onto your profits or onto your land and take that those minerals or gas or oil is because they have an interest less than an estate, and it's called profits a prondra, the taking of profits out of the land. Okay? All right. Now we're getting down to the transfer of land. So we've talked about what property is. We've talked about all the interests in land. Now, how do you buy and sell land? There are three ways that land can be transferred. One is by statute. This is a situation where you have a will, or if you don't have a will, then the property is transferred what they call intestate, which means without a will. We have one statute in the province of British Columbia now. We used to have a number, but it's called the Wills, Estates, and Succession Act. So by statute, intestate, it goes by the Wills and the Estate and Succession Act that the property is either goes to the beneficiaries under a will or to the heirs of the estate if there is no will. And they're both governed by the one statute now. It used to be we had an Administration of Estates Act. But now we've modernized it and combined it. Okay, so by statute, intestate, which means a situation where the owner dies and there are no heirs or beneficiaries. What happens to the land? It escheats to the crown. Okay, do I actually have that term in there? No, I don't. I'm going to go back and put it in. Escheats to the crown. So the ownership of the property reverts to, well, the queen, because she owns the property, and if there's no one with a freehold interest in the estate, then it goes back to her. The other way is by will. By statute, it either escheats to the crown or it goes by what they call letters of administration to the heirs. Okay, and then by will means that it goes to the beneficiaries, and again, it's still under that same statute. All right. The third way is by grant. Okay, so if I own free simple interest in a property, I can grant ownership to someone else, which means I transfer ownership to them. And I'm going to have to make a change to that slide and make that a little clearer. Okay, enough said about that. Let's get into leasehold interests in land. And there is a portion of the textbook that deals with this, and it's in Chapter 9. So it's just a portion of Chapter 9. I highly recommend that you read it. So leasehold interest is created when a landlord, the lessor, grants a term to a tenant, the lessee. A term is an interest in land for a definite period of time and a reversion of the interest to the landlord. So what we're talking about here is a definite term, which is a little confusing, but when you stop and think about it, if you have a month-to-month lease, how can there be a definite term? Easy. It's the term. It's actually a succession, of 1 month leases. Okay, so the term starts at the beginning of the first month and ends at the end of that month. The new term starts at the beginning of the next month and ends at the end of that month. Oh, pardon me. End of that month, and so on and so on and so on. Or you either have a 1-year lease or a 6-month lease or a 5-year lease, and then there's obviously a definite term. 2 types of tenancy relationships, residential tenancy and commercial tenancy. I am not going to talk about residential tenancy. We have a Residential Tenancy Act, and it's really straightforward and designed to be used by residential landlords and tenants. And we also have the Residential Tenancy Branch. So if you had a question and you came to me when I was a practicing lawyer and you said, I have this problem with this residential tenancy matter, I would 9 times out of 10 say, look, go to the Residential Tenancy Branch, deal with them. They're very helpful and it's all very straightforward. Commercial tenancy, not so. Okay, it's there's a Commercial Tenancy Act, and if you ever decide to rent commercial premises, I highly recommend you take a quick look at that statute. Okay, you do have exclusive possession to the property, and you, wait, I don't own it. How can that be? When you lease the property, you have control over that property, even to the exclusion of the landlord, except as provided for in the lease. As I mentioned, a definite or ascertainable purpose, ascertainable term for a lease. And then there's 4 classes of tenancy, which we're going to deal. And this will make a really good Part B exam question. There are 4 classes of tenancy, but one of them, it's put on there to deal with the occupancy of someone else's land, but without anything like a lease. Okay, but to complete the how people can occupy somebody else's land, it has to be put on there. Okay, so the first is a term certain. A term expires on a specified date. Okay, now what you have to remember here, and here's a term that you should know for this course and for your business life. Otherwise, it's going to come back and bite you. Overholding tenant. My husband and wife, restaurant owners that had a corporation, had a problem with this. And what happened was they had a lease on property, and the lease was coming up for expiration, and it provided for the negotiation of an additional term. And so the husband is the baker and the wife is the business person, and so she was taking care of it. She kept calling the landlord, and she said, okay, we have to decide on what the length of the next term is and how much the rent's going to be. And the landlord said, yeah, I'm really busy right now. Call me back later. Call me back. Well, we have to decide. Call me back later. And it was getting closer and closer to the termination date. And so the landlord pulled a fast one on her. He said, okay, I tell you what, look, I'm really too busy. I can't do this right now. We'll have to do it later. So why don't you just stay in the premises and pay what's required under the lease? And she says, oh, okay, sure. So the end of the term expires. She stays in the premises, submits the rent for the next month, and the landlord says, oh, no, that's not the right amount. And she said, what do you mean? It's in the lease. That's the amount. And he says, no. Check section such and such of the lease because you actually owe me twice that. And she checks the lease, and there was a paragraph that said, in the event that the lessee becomes an overholding tenant, the lessee shall be required to pay double the rent. And she goes, oh my God. She calls me up and she says, am I an overholding tenant? And she described the situation, and I said, yes. And she says, but that's unfair. And I said, well, you signed the lease, and this was before I became your lawyer. So, what lawyer did you have? So I didn't use a lawyer. I just, read it. And I said, well, what did you think when you got to overholding tenant? And she said, well, I didn't know what it meant, but, I didn't think it would be applicable. Okay. Anyway, overholding tenant. If you stay in there, some leases say just pay the regular rent, some pay rent and a half, some pay double the rent. But you do not want to do that. You can, put in an arbitration provision in the lease. Okay, I'm back to my arbitration, so that in the event that the matter goes past the term and the landlord demands double the rent, if you can substantiate that it was the landlord's suggestion that you just stay in there, then you might be able to get the arbitrator to say, okay, well, it would not be just to force you to pay double the amount, right? Or you can go to arbitration, force arbitration before the expiration at the end of the lease to determine what the term and the new rental amount should be. Okay, so that's term certain. Periodic tenancy, term renews itself on the last day of the term for another term of the same duration. Okay, quite a few commercial leases are like that. Most residential leases are like that. So what's that mean? Well, it means that if your term comes to an end, you can just leave at the end of the month, eh? No, you can't. There's a requirement of giving notice, okay, specified, I believe, in the Commercial Tenancy Act. But most landlords do not have a month-to-month lease. Okay, they will want a 6-month lease, a 1-year lease, a 3-year lease, a 5-year lease, and they negotiate it with you. Let's say you have a 5-year lease, and you want to leave early. Well, you can give 1 month's notice, right? No, that's residential. Okay, under the Commercial Tenancy Act, if you wanted to leave after 3 years of a 5-year lease, you're technically supposed to pay the other 2 years. The courts have stepped in, and the guiding principle is that you have to pay 6 months to get out of a lease. So, well, thank goodness, just 6 months. But if it's a $12,000 monthly rental, you have to pay $72,000 to get out of the lease. So you want to make sure that this is dealt with in the commercial lease that you sign with the landlord. And I did talk about surrender of lease when I was talking about discharge of contracts by waiver. Let's say you want to leave the premises, and you go to the landlord, and the landlord says no. Then you have to pay 6 months to get out of the lease. Let's say you go to the landlord and you say, I'd like out of the lease because I have to find bigger premises. The landlord says, well, okay, because I could actually probably rent it at a higher amount per square foot. So you agree and you leave, and then the landlord cannot rent at a higher rate. As a matter of fact, has a hard time finding a tenant because something happens in the meantime, like COVID-19. The landlord can then go back and say, well, that was a verbal agreement, but this is a contract concerning land that for over 3 years, and they have to be evidence in writing. You don't have evidence in writing. Oh, yeah, no, I have an agreement from you. Yeah, but it isn't binding because there's no consideration going both ways. So what you want to do is you have that arrangement to get out of the lease. Then you want to have a surrender of lease signed and signed under seal. At least the landlord signing under seal. Okay, it's not likely you're going to sue them because you want to pay rent. It'll always be because he's suing you because he wants you to pay. Okay, surrender of lease signed under seal. Here's something to think about, and this is legal advice that's unethical but practical. My brother-in-law in Victoria and my sister decided that they wanted to have a retail store in a mall in Victoria. And they wanted to sell toys, but not like cheap toys. They wanted to sell educational toys, toys made, very expensive ones imported from Europe, and they also wanted to sell Indian art because my brother-in-law was a native carver, and a good one. He has a paddle on display in a museum in Los Angeles, and one of his masks was purchased by a Japanese princess. So he's pretty good. Anyway, there was a store in the mall that we don't know the reason, but the tenant wanted to get out, and it was a toy store. So my brother-in-law says, can I take over the lease? And the landlord says, sure. So they do an assignment of lease, and my brother-in-law and sister move in. And shortly thereafter, the landlord said, you have to stop selling the native art. And my brother-in-law said, whoa, wait a minute, that's like the biggest amount of our revenue, because this is Victoria, cruise ships come in there, travelers come to the capital of the city, and the shop is right downtown. And the landlord said, well, I'm sorry, you're going to have to stop because your lease says that you can only do the type of activity specified, okay? And it says toy store. And there's other shops that sell native art in the complex, and they've demanded that you stop. And so he stopped selling his native art, and the revenue dropped off, and pretty soon he's paying the rent not from income but out of his bank account. And he came to me and he said, "Look, I really got taken by the landlord, and so now I'm going to have to get out." And he said, "I cannot afford to pay 6 months rent to get out." And so I said, "Okay, well, here's something you can do. It's not legal, but it might work." And I told him to do a midnight move. I said, at the end of one day, put all the inventory, the toys, into boxes and take them home. And put a lock on the door and just send a note to the landlord saying, "We've left." And he said, "But he said he would sue me." And I said, "Yeah, he may, okay, but you're losing money anyway." And I said, what you want to do is you want to give him notice, and then he'll have that vacant space, and that's not a good idea. Have you seen malls with all the vacant space? Like, try to get a renter to move in there. They go, "Why would I move in there? There's like no tenants." So the landlord does not want it vacant. So he re-rented it like that. Okay. Somebody else went in, but they didn't want to do a toy store, so they wanted some other kind of store. So they write into the lease what it is they want to do, and bingo, they sign it. And I said to my brother-in-law, he probably will not sue you, but even if he does, he will not have suffered 6 months damages, because you have to mitigate your loss or you don't get what you claim. And what loss has he suffered? Well, my brother-in-law had paid the first month's rent and the last month's rent. So they left, and the landlord had 1 month's rent. Okay? And it was vacant for a month. So the landlord was paid for that month, and then he had a new tenant, which was paying actually greater rent than my brother-in-law was paying. So the landlord has not suffered any damages. So he could have gone to court. He could have taken my brother-in-law and sister to court, and he would have won. But he would not win anything because he did not suffer a loss. So in that situation, they generally give you what they call the lowest coin in the realm, which you'd think would be a nickel. Back in those days, it would have been a penny, but we don't. We give $1. Okay, I don't know how they figure that's the lowest coin in the realm. But anyway, so I said, do that, and you may not be sued because the landlord will talk to his lawyer. The lawyer will say, how much money do you want me to pay, or want to pay me to get nothing? And if you are sued, then you'll only have to pay probably the lowest coin in the realm. So he moved out, and he got the threatening letter, and nothing ever happened. So that's something to think about if you're ever a tenant in that situation. And of course, if you're the landlord, then obviously you'll have or should have a lawyer, and the lawyer will tell you that there's no point in suing. Okay, so that's periodic tenancy. Tenancy at will. The tenant is in the premises merely at the landlord's will. All right. I'll come back to that one because that's the tenancy situation that really isn't a tenancy. Tenancy at sufferance is a person who entered into possession rightfully under a lease but now stays wrongfully after the expiration of the lease. So this would be a situation where you have a 1-year lease and you just stay there, and the landlord wants you out. Well, the landlord's going to have to take steps to get an order of forfeiture and kick you out. And seek damages from you for staying in there and causing the problem. Or it might be considered to be the situation where my husband and wife baking restaurant operation entered their lease rightfully and then stayed wrongfully. I don't suppose so, because there was a provision in the lease for what happens if they are an overholding tenant. Well, yeah, you're an overholding tenant, so you're there wrongfully. Okay, and you have to pay double the rent. So that would be an example of that. Back to tenancy at will. In New York City, there's lots of, well, not lots, there's some buildings that are vacant, okay, because they're so run down that the city has said, okay, you have to, update the stairwells, you have to put in new elevators, you have to put in a new heating system, the electrical wiring has to be replaced, as does the insulation, and the owner cannot afford to do that. So what the owner will do is they'll close up the building and make sure that it's vacated and close up the building. And then they wait for a buyer to come along, wait for the development of the block or something to make it worthwhile. There's so many homeless people that what they'll do is they'll come along and they'll break into the building. There's no light, there's no heat, there's no water, but there's shelter. Okay, and so they break into the building and they stay there as trespassers. So the landlord comes along and goes in and says, okay, everybody, pack up and get out of here. You're trespassing. And we'll do that periodically to make sure that they remain as trespassers and have no squatters' rights. And that way, if eventually he sells it, he can get them out quickly for the redevelopment. The landlord goes away and these people move back in. So the landlord could call the police and have them kicked out. And sometimes they would if there's a development permit or something. But for the time being, it's a tenancy at will. They're just at the will of the landlord. Okay. COVID-19, people aren't paying their rents, leases expired, they're tenancy at will, okay, at the will of the landlord. I suppose the landlord could probably bring an action to see if the government's order that they can't be kicked out is enforceable or not. Okay. All right. Here is one of the biggest dangers associated with renting commercial premises. And that's called the offer to lease. Now, the offer to lease is a good idea, but you have to be really careful how the landlords handle it. The offer of lease is generally prepared by the landlord, but it's intended to reflect the tenant making an offer to the landlord. And what happens here is one of the things I always recommend to my clients when they're thinking about renting premises is to go to the landlord and say, my corporation wants to rent it. And they say, sure, we'll rent to the corporation, but we want you to covenant that you'll pay if your corporation doesn't. And you go, bye, and you leave, okay? Because there's generally more space than there are tenants available. And so you're a little bit in the driver's seat, okay? And so you can say, all right, I'll rent, but I will not give my corporation will rent, but I will not give a covenant. And if the landlord demands the covenant, then you leave and go somewhere else, because there's another landlord out there who will say, okay, I'll take your corporate tenant, because it's better to have somebody paying the rent and maybe having trouble than having it vacant, okay? My Sylvan Learning Center client, which I've talked to before, was going to open up his shop in a leased premises, and he said to the landlord, my corporation will lease it, and the landlord says, I want you to sign a personal covenant. And my client's name was Pat, and he said, nope, sorry, not going to do it. I'm a franchisee of a huge international organization. We're the franchisors in Delaware, and everybody knows it, and the revenue's coming in, and there's just no way that I think I should have to sign a personal guarantee. So the landlord said, sure, fine. And so there's this offer to lease that comes out, and in there it says, what the deal is between the landlord and the tenant. And it gets to the end, and it says, and the tenant shall sign a lease, the landlord's standard form lease, a copy of which is attached here too. And the lease wasn't attached. And fortunately, Pat was one of those clients that actually gets to his lawyer on time, okay, before he signs a deal. So he called up and he said, look, I've asked the landlord numerous times for the lease, but it isn't attached. And he keeps saying, oh, well, don't worry about it, sign the order to lease, and then, we'll send over the lease for you to sign later. And so I called up the landlord and I said, look, he wants to see the lease beforehand. So the landlord said, oh, gee, God, was that a problem? Okay, well, send it over. And they sent it over, and there was a line for the corporation to sign, the name of the corporation per authorized signatory, and Pat was supposed to sign there, and then underneath there was a line with Pat's name underneath and a red seal beside it. Pat gets it, and he calls me, and he says, okay, what's the place where I have to sign the second time? And I told him that's the line where he's covenanting to sign and be liable in the lease before, or if the corporation can't pay. And he said, but that's not the deal. And so I called the landlord on his behalf, and I said, look, the offered lease says he does not have to do that. Here's the lease that you want him to sign, and there's this line where he has to sign personally. What's going on? And the landlord said, oh, golly gosh, gee, oh, hey, that's just a mistake. What happens? I mean, I make the deal, and then I give it to my staff, and we always ask for a covenant. And so when my staff did the lease, well, they didn't check, and they just put a line in. And you get the feeling, right? Well, it might have just been a mistake, okay? But had my client signed it, the lease then becomes the deal, the offered lease is null and void. 2 years later, there's a problem. The corporation cannot pay. They come to him, Pat, and they say, okay, Pat, you have to pay. And he'd say, but that wasn't the deal. Go to court and then tell the judge that you signed it without getting a legal advice, and the judge will say, hey, you're bound, okay? Now, that was just a coincidence, except he's leased 3 other buildings, and 3 out of the 4 times the landlord sent the lease down with a line for him to sign personally, even though the deal was that he didn't have to. Okay, so maybe they're just sloppy, but the problem is you want to make sure that you have your lawyer look at it and talk to your lawyer before you sign on the dotted line. I had another client. Well, no, that situation is too long, and it's the same point. Okay, all right. So offer to lease. Make sure that the offer to lease reflects your deal. I do have one other that I should probably mention. Another person who became my client because of the problem, just outside UBC, there there's the endowment lands, and then along the way there's the commercial area and residential area. But just on the campus grounds, there's one little part that doesn't belong to UBC. It's actually commercial property, and it has a few stores in there. And if you can get a store in there selling something to students, it's like a gold mine, because what do they got? 16 or 18,000 students, and there's your shop. I had a client, a fellow who became my client because he wanted to rent a shop in there to sell books, textbooks, because he was a textbook buyer. And what he would do is he'd buy up all the Physics 101, all the Chemistry 100, all the English 100 books from other universities that were left over. And he would sell them at way less than UBC was selling through their bookstore. And so it was just, he actually eventually made a fortune and got out of that particular operation. But when he went there, he got the offer to lease, and it said, sign a lease, a copy of which is attached here too, and it wasn't attached. And he, the landlord said, "Oh, sign the offer to lease, we'll send it over." So he signed the offer to lease and gave them $18,000, first month, last rent. And then the lease came over, and he did not like the lease. And he was told to get in touch with a lawyer, and he got in touch with me, and I said, "Well, that's too bad. You signed the offer to lease. So either if you don't want to move in there, you can, you don't have to, but you'll lose your $18,000 deposit." Okay. So the offer to lease is legally binding once you have made it to the landlord and the landlord has signed it. Okay, you sign it and it goes to the landlord. Landlord signs, it's the contract to enter into a lease. And he moved in, and as it turned out, he was there for like 5 years, and he basically made a fortune. Anyway, the offer to lease, final and binding. You pay the deposit, sign the offer to lease. You don't like the lease? Too bad. Okay. All right. Now, covenants in the lease. We have covenants that run with the land. Well, covenants in a lease, pretty much the same thing. The first covenant is that you must pay rent. I'm just going to look at the next page. No, there's something missing on my slide. Okay. You must pay rent. And there's no right of set-off. What's that mean? In the lease, it'll say that you have to pay the rent on the first day of every month, or on the last day of every month for the next month, whatever. And there's no right of set-off. What that means is that if the landlord owes you any money for any reason whatsoever, you do not get to subtract that money from the rent that you have to pay. So quite often the landlord will give you an inducement to enter into the agreement. They'll say, "Oh, leasehold improvements are going to be $60,000. Well, we will pay $30,000 of that. So you move in, do the leasehold improvements, give me the bill. If it's $60,000, we'll pay half." And what happens is you sign the lease, you move in, do leasehold improvements, and then the landlord, delays and delays and delays paying, and you think, well, he owes me $30,000, and my monthly rent is $15,000, so I'll just not pay 2 months, and then we're even. You have to pay, and then sue the landlord to get that $30,000 that he's agreed to pay you. Okay, if you do not pay, they can actually slap a lock on the door and take the premises back. Okay, so payment of the rent is a covenant, no right of set-off. Right to assign or sublet. You want to have a look at the clause, because you may be in there and you may say to yourself, okay, this is great, but I need more room, so I would like to move out. And you get the landlord to agree because you found a tenant that will move in. Okay, well, that tenant moves in. how does that tenant take over your contract? Well, you assign the lease to them. Okay. The assignment clause should read like this, and I used to not tell my students this because it was specific legal advice that I charge for. Okay, you want the lease should not say the tenant has the right to assign or sublet the premises with the landlord's consent, because the landlord could decide no for any reason whatsoever. It doesn't have to be reasonable. And so lawyers started putting in a clause that said the tenant shall have the right to assign or sublet the premises with the consent of the landlord, which consent shall not unreasonably be withheld. So that means if you had a good tenant that wanted to move in, they couldn't just say no. All right. Well, there were a few court cases about this, and so now it should be changed, because you're covenanting that you will not assign or sublet without the consent of the landlord, but the landlord isn't covenanting that the consent will not be unreasonably withheld. So what you want to do is put in that the tenant shall have the right to assign or sublet the premises with the consent without the consent of the landlord, which the landlord covenants shall not be unreasonably withheld, because then that allows you to sue for damages. Okay. All right. Assignment and sublet. Restrictions on the tenant's use of the premises. This is what caught my brother-in-law in Victoria, because the lease that he took over said just toy store. Okay. Not only my brother-in-law and sister got caught on that, but a law firm got caught on that. There was a law firm that was renting in the Burrard building downtown, and the Burrard building was going to be gutted and redone. And so their lease was coming up, and they knew they were going to have to move. So they moved into the most prestigious building in Vancouver at that time, called Park Place. And they went and they made a deal with the landlord, and they got the lease, and it said law firm and legal services as the business that they were going to use the premises for. In the previous building, the law firm is so big, it had like almost 200 lawyers or something, that they found it really economical to have their own cafeteria. Okay, now lawyers working in his office, work, and the stomach goes off at about 11:45, right? Work, and suddenly you're hungry. So the lawyer will get up and he'll go out and he'll have lunch. And it'll be an hour lunch. Maybe he meets a friend, or goes for a walk in the park, or whatever, an hour and a half, and he comes back. Like, it could be 2 hours. Okay, so the law firm would lose 2 hours of billable time for that lawyer. So what they did was they had this cafeteria right there where you could go and get the food. And better still, just before noon, people from the cafeteria would come by with a tray of sandwiches and desserts and milk and coffee and stuff. And they'd come to your office, and you're working and go, oh yeah, okay, sure. And they'd actually pay the firm to buy food and stay at their desk and continue working. So it was a really good deal for the law firm. So anyway, they're moving from that building, and one of the restrictions on moving to the next building was they had to have the design of their office approved. They gave the architectural drawings to the landlord, and the landlord goes, what's this here? Cafeteria. And they explained that they wanted a cafeteria. And they went, no can do. And the law firm said, well, what do you mean? What do you mean no can do? They've already signed the lease and paid the deposit subject to paid the deposit, and they had to get the drawings approved. And the landlord said, well, because in the use of premises, it says law firm and law firm services. It doesn't say anything about food services. And we have a food court downstairs, and all the businesses in the food court want the people to come down out of the building and go to the food court. And the law firm got stuck. Okay, they had to move in there and lost their cafeteria. All right, so you have to be careful. Fitness for occupancy. Um, quiet possession doesn't mean shh, be quiet. Okay, we'll come back to that. Fitness for occupancy might mean shh. The Sylvan Learning Center client moved into this building and they had their premises and they'd been operating there for quite some time when the premises next door became vacant and the landlord, in its infinite wisdom, decided to put in a dance studio next to an educational business. Well, you can, here they are doing tap dancing. And the noise was even amplified by the fact that this was a steel beam construction, and the noise from the dance studio was just horrible in the premises. Okay, so Pat called me up and he said, "What do you do?" So we sent them a landlord a notice and said the landlord is in breach of the lease because the premises are not fit for occupancy. And the landlord said, "Oh, geez, sorry about that." So the dance studio had 2 dance floors, 2 rooms. And so in the one room, they built a subfloor to stop the noise. But because it was on the steel beam, the noise was just as bad, okay? So they built a subfloor in the other room, and still the noise was bad. Finally, it wasn't until after that they moved the dance studio at huge cost. Otherwise, my tenant could have left and broken the lease because it was unfit for occupancy. Okay, so that's what that means. Repairs, repairs, reasonable wear and tear accepted. That's the way it reads. So there's carpeting or tile. Eventually, it's going to get worn, have to be replaced. The landlord pays for that. Repairs, somebody comes in with a tray of coffees and stuff for a meeting, and it spills on the carpet, and the carpet has to be repaired. The landlord pays for that. Okay, the tenant pays for that. Tenant pays for repairs, reasonable wear and tear accepted. Now, my husband and wife baker operation, they had this one restaurant with the big oven, and they do Italian food, and it's real Italian food. The baker is a master chef trained in Switzerland. So when he's doing Italian food, it is actual Italian food. So they decide they have to have an actual Italian oven so that it is authentic Italian food. So they bring in an Italian oven from Europe, and they go to pull out the old oven, and the whole wall behind it was just collapsed because the steam from the oven got into the wall. And had they not moved the oven, it would have been fine, but when they tried to move the oven, the whole wall basically collapsed. And the owners, my clients, called up the landlord and said, you got to repair that because that's reasonable wear and tear. And the landlord said, no, had it just collapsed with the oven there, then it would be reasonable wear and tear accepted because there's steam and moisture from the oven. But it collapsed because you removed the oven, and so my client had to pay for it. Quiet possession. Remember a little earlier on, slide 118, it says exclusive possession. When you're renting a place, you have control over the land as opposed to a mere right to use it in common with others. So quiet possession means that you can exclude everyone from the property, even the landlord, okay, at common law. So what happens in this situation is the landlord wants to check the premises out every once in a while, and so the landlord will put into the lease that the tenant shall have quiet possession of the premises subject to the landlord's right to, upon 10 days notice, indicating that they want to come in for certain hours during non-operational time to check the premises. Okay, So they have to do that, otherwise you can tell the landlord to go away. Insurance, you have to check this. The tenant will covenant that they will have corporate or commercial tenancy insurance or product liability insurance or what's the other one? Professional insurance, depending upon the nature of the operation, and the landlord will say that they have insurance on the premises themselves and something like that. Services, the tenant will covenant that they will pay their proportionate share of services for the building. So that's garbage collection, heat, light, things like that. Okay, so those are the standard covenants. Just to complete the topic of landlord and tenant, we're going to talk about termination. Okay, remember the discharge of contracts. This is where that comes in. If you want to get out of the lease early, and you get the agreement of the landlord, you want to have a surrender of lease, and you want that signed under seal. What happens though if the tenant just leaves, like my brother-in-law did? Well, does that get the right to the landlord to just move in and take over the premises and rent to somebody else? No. For example, if my brother had left and then 1 month later turned up and said, okay, here's last month's rent and the next month's rent, I'm moving back in, and the landlord says, well, there's already somebody there, then you got a court case, right? And the tenant will win that. So you don't have a surrender of lease, and so how does the landlord protect themselves to ensure that the tenant isn't going to turn up and say, here's the back rent, I want back in? Well, the landlord has to get a forfeiture of the lease, so they have to go to court and get an order for forfeiture. Okay, I don't know whether the landlord did that with my brother-in-law's situation or not, because we didn't care. Okay, last topic, option to renew. This is a risk management consideration. You have premises for your business. If the location is extremely important, then what you really want to do is have a long-term lease so that you're insured about being there. The problem with that is you're not sure whether your business is going to survive or not, so you want a short-term lease. But then you might have to move. So what you do is you take as short a term as possible that the landlord will grant to you, and then you get an option to renew for an additional term. So a 1 year lease with an option to renew, 1 year, and that's 1 year with an option to renew that. Okay. Now you have to agree on the rent and the amount of the subsequent term. Unless you say it's a 1 year lease with an option to renew for an additional 1 year at a rent to be decided upon, for another 1 year with a rent to be decided upon, because then it's only the rent that you have to work out. What happens if you cannot work the rent out? Well, you go to court. But you don't want to go to court, so you put in an arbitration clause, mediation and arbitration. So you have a mediator who will then say, okay, the rent was this, the rent's in the general area and the certain type of business is this amount, so I think it should be that amount. The parties will either agree, or then if you can't agree through mediation, then you go to arbitration, and an arbitrator will say, okay, that's the amount of rent for the next year. All right. So the next topic is mortgages on land, and I think at this point I'll have a break, and I'll post the land portion video and then a mortgage portion as well, rather than lumping it all together. So thank you very much.